Good morning and welcome to another presentation. In this presentation I'm going to explain what the term without prejudice means. Many times when we see documents that come from lawyers' offices that says without prejudice, or in some cases we want to have a meeting on a without prejudice basis. I think it would be very important to know what this term means so that you can use it effectively and not potentially make a mistake which might be detrimental to your court case. This is a fairly short presentation with only a few slides. I hope you find it useful, and I look forward to bringing you more content as I have time or as the request comes in. This presentation is actually a result of somebody advising me on the Without Prejudice paperwork or information on one of their pages they received from a lawyer. The phrase without prejudice is a legal term used to indicate that the statement or communication is made in course of negotiations to settle a dispute, and that it should not be used as evidence against the party making the statement if the negotiations fail. This is why if you sign your document on a without prejudice basis, the other party may motion the court to have that information stricken, because the evidence is not to be used as a statement if the negotiations fail. Therefore, the only time that you can use a without prejudice document in court is to prove that you tried to make a settlement. So I will reread this statement. The phrase without prejudice is a legal term used to indicate that a statement or communication is made in the course of negotiations to settle a dispute, and that it should not be used as evidence against the party making the statement if the negotiations fail and the matter goes to court. This means that parties can make the concessions with a promise, without fear that their words will later be used in court against them to prejudice their case. The without prejudice privilege is a rule of evidence that allows parties to have open and free discussions to try and settle a dispute out of court. It is often used in written communications, such as letters or emails, to indicate that the contents are not intended to be used as evidence in court. However, the mere inclusion of the phrase without prejudice does not automatically grant privilege to the communications. The substance of the communications must reflect a genuine attempt to settle an existing dispute. As I've stated many times in my previous presentations, you always try to settle your disputes prior to going to court. In this context, then, you would put without prejudice on your documents, and you might come in with 20 or 30 or 40 allegations, and if you have this without prejudice communication, you might be able to whittle it down to 10 or 15 issues that you need to bring up in court. This is why when I do paperwork, I don't write without prejudice on a document unless it is in fact needed in that case. In fact, I want my documents to be used with prejudice because I want to show the communications, and I want to use it as evidence. The main purpose of the without prejudice is to encourage the parties to negotiate and settle disputes without fear of their statements being used against them. This promotes productive discussion and allows parties to work openly and freely towards a compromise without the risk of their statements being used against them should the negotiations fail. This is why I state don't put without prejudice on a document unless you know what it means. Now, there's many times when a person will have a meeting or request a meeting on a without prejudice basis. This again is another attempt to reach a negotiation without the fear of what's being said at that meeting being used against them. So if you state something out of context, potentially at this meeting, the other side won't use it against you in a court of law. Both parties will have to agree to this without prejudice meeting. The without prejudice meeting may resolve your problem and may in fact eliminate the need for you to go to court at all. If that was the case, then you would simply file a discontinuance. Now, if the other party brought the action before the court and you are the defendant in this case, sometimes they will try to trick you and they will ask you to file a discontinuance in trial. Don't fall into this trap. Given the fact that the other party is the moving party trying to bring the action into court, you would only file the discontinuance if they filed the discontinuance first. You can agree to that on a without prejudice basis with your communications, or with prejudice, doesn't matter. But I would use with prejudice because I want the other party to agree in writing that they will file a discontinuance because you've reached a resolution. And then once you see that discontinuance and you can confirm that with the court, then you would file your discontinuance if you had filed a statement of defense or a statement of defense and counterclaim in this situation. There are some exceptions to the without prejudice rule. For example, if a statement or a settlement, is reached and one party reneges on the agreement, you can now use your without prejudice document as evidence that it was presented on a without prejudice basis, be admissible in court to prove the agreement was reached. Additionally, if the without prejudice offer was induced by unfair influence or misrepresentation, the offended party may be able to exit the agreement made. In this case, you would be able to use this without prejudice document on that basis and file a motion in the court to have the agreement or settlement reversed. In summary, the without prejudice is a legal term used to facilitate open and free discussions in a settlement of disputes. It allows parties to make concessions and promises without fear their words will be used later in court to prejudice their case. However, the privilege is not absolute and there are exceptions to its application. I hope you found this information useful, and I will bring you further information as time progresses. Thank you.